Good morning to you both. The next matter to come before the court is State of Ohio versus Maurice E. Korn Sr. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. Mr. Lanier, as you are the appellant in this case, representing the appellant in this case, please let me know when you get started about how much time you would like to reserve, if any, for rebuttal. Please don't use the names of any minors or victims in this case, as we are live streaming and also recording this oral argument for posting on the court's YouTube channel. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honors. May it please the court, Mr. Sheldon. Thanks for permitting this oral argument. I apologize, the background's not as nice as maybe the other ones, but we don't have a camera on my regular monitor, so we borrowed a laptop. We have it up and running, so we'll do the best we can with what we have. Is the audible okay on that end? You can hear?
Fine. Yes.
Okay, thanks. So we ran a motion to suppress on this case involving Mr. Korn some time ago. Procedurally, he was charged with operating a vehicle under the influence and a prohibited BAC. There was not a minor misdemeanor moving violation or anything like that. Mr. Sheldon was retained by Mr. Korn. They entered a not guilty plea. They filed a motion to suppress. We came in for the hearing. It was in front of an acting judge who ruled right from the bench at the close of the hearing and then followed that up with a written decision. So factually, and I don't think the facts are highly contested. This involves Sergeant John Nemistel from the Highway Patrol, a 10-year highway patrolman, went to the Ohio State Patrol Academy. He's been a sergeant for about 4 years. And he comes across a car on the side of the road, I-71, which is a interstate highway, runs through Medina County. He sees a car on the side of the road with either flashers or blinker on. So as part of his testimony, he indicated it's their policy to stop and check on the vehicle, see if there's an occupant or occupants. So Sergeant Nemistel does that, and he identifies Maurice Korn as the operator of that vehicle, and there's also a passenger in that vehicle. He approaches, he does stop, he approaches that vehicle. He has some discussion with Mr. Korn, and he makes several observations right away, beginning with Mr. Korn indicated that he had stopped to use the bathroom, and he was going to look at his GPS device. So this is the side of 71. It's not a facility to use the bathroom. So he continues talking to him and makes some other observations, which include red, glassy, bloodshot eyes, some slurred speech. He notices a unlit cigarette dangling from the defendant's mouth, from Mr. Korn's mouth. And when he inquires about the consumption of alcohol, Mr. Korn does make an admission to consuming alcohol prior to driving. At this point, the odor that he observed, he cannot identify as to from the passenger, from the driver, from the upholstery. At some point, he has Mr. Korn exit the vehicle, and at that point, he is able to pinpoint that the odor was in fact coming from Mr. Korn's breath. So the suppression motion was granted on the basis that there was not enough reasonable suspicion to get Mr. Korn out of the car and investigate any further. So we filed notice of appeal, meaning the state of Ohio, and we filed our brief. It's the state's position that Sergeant Nemistel was reasonable in furthering this investigation. I don't think the defense is disputing that this began as community caretaking function, and I think that's in the entry as well. But when it starts as that, there can be other observations which then propel it into further investigation. And the question is not obviously whether or not Mr. Korn is guilty or innocent of any specific offense at that point. Was the sergeant reasonable in following up? The state's argument, and obviously I've cited some cases and argued in the brief, is that Sergeant Nemistel was reasonable in this case to follow up on this. Those amount of observations warranted Sergeant Nemestol to have Mr. Korn get out of the car, pinpoint the odor, and then continue the investigation. Now, I filed my initial brief, and then Mr. Korn and Mr. Sheldon filed their brief, and they rely quite heavily on a case this court decided years ago, State versus Ian High. And I'm pretty familiar with the case because I ran the hearing and then I did the appeal and we lost. Mr. Sheldon's pretty familiar with it too because he was on the other side. Now, the case of Ian High, has been a thorn in our side since the decision, but I think it's misplaced in the argument here. In State versus Ian High, and I'm sure this court's familiar with it, Sheriff's Department responded to a man at a residence threatening to harm himself. As part of a side note, there's a vehicle in the driveway, which Mr. High is in, and one deputy tells a sergeant tells a deputy or vice versa, hey, you might want to check on this guy before you let him go. So they're out there for something completely different. They're checking on a suicidal man who's inside a residence, and this is a car that's on the driveway. In that case, they had a very limited amount of observations from Mr. High, and they asked him to get out of the car. And I believe it may have just ended up being a physical control charge, but in any event, the same motion to suppress was filed by Mr. Sheldon. And in that case, prior judge Dale Chase determined that there wasn't enough, just based on, in that case, all we had was an unspecified odor and an admission. So we had two things. And when you look at that case and you read that case, I felt that this court was really suggesting, that just only two indicia is not enough. And they, in that decision, had even suggested, had there been glassy eyes, had there been some slurred speech, had there been some red and bloodshot eyes, had there been a measurable or a quantitative descriptor on the odor, then we may have been okay. But two indicia alone, they determined was not enough. Interestingly, they said that in that case, because this was a case where one officer tells another officer, you might want to check, the court had suggested, had the state brought in officer number one to testify, maybe we would have reached that hurdle. I guess I would argue that the decision to get him out of the car was based on officer number two and what officer number two knew at the time. So what officer one observed wasn't really the issue. The issue was, what did officer two know at the time he asked him to get out? And all he knew was, you might want to check on him. So, I don't see this as being a case that's on point with State versus Ian High. In this case, we had those two same observations, which was an admission, and we had an unspecified or nondescript odor of alcohol. But in this case, we had quite a few other things. We presented testimony about the experience of Sergeant Nemestol. We had the additional observations of red bloodshot glassy eyes. We had slurred speech. Again, we did have the odor in the admission, but we also had 10 at night on the side of the highway looking to use the bathroom. And then we had an unlit cigarette hanging from Mr. Korn's mouth. Any one of those things in and of itself would not be nearly enough to make probable cause, let alone proof beyond reasonable doubt. But was Sergeant Nemestol reasonable in asking Mr. Korn to get out of the car? And again, the state's argument is that it was. If you look back at the judgment entry the acting judge put forward, there's a couple, things that the state takes issue with. His whole assessment begins, on page 4 of his entry was the defendant's vehicle was properly parked on the berm. Well, it wasn't properly parked. You can't park on the side of the highway. That's the whole reason when there's a vehicle parked on a highway or it's not supposed to be parked, that Sergeant Nemestol decides to even stop. So, the acting judge, I think from the beginning, didn't have a clear take on what was going on here. My second issue was the judicial notice of a speech impediment, which, even if, and I argued this, even if you could take judicial notice of such, and it doesn't fall in either of the two categories of a fact that can be judicially noticed by the court, The fact that he put, the court takes judicial notice of the speech impediment from the bench and finds that it's not an indication of impairment in and of itself. Well, the error was taking judicial notice of it, but even if that was a fact that could be judicially noticed, and even if the court was proper in taking judicial notice of a speech impediment, that's not the decision that needed to be made. The decision was, could this slurred speech be an indicator that could be considered by Sergeant Nemistil in deciding to continue this investigation? Now, beside the fact that Mr. Korn never proposed a basis for the slurred speech, even if he had proposed that, hey, I had an injury years ago from boxing, and that's why I have slurred speech, and I do have slurred speech, even if he had said that, the state would argue that Sergeant Nemistil, in combination with all these other factors, could consider slurred speech, again, as a reasonable basis just to continue the investigation.
And counsel, you have a little less than 5 minutes remaining. You may continue or reserve any time for rebuttal.
I'll just continue and
Okay.
finish up here, and then I'll pass the torch to Mr. Sheldon. So again, the state's argument on this first part, I don't think it's in dispute. This started as community caretaking. Those types of initial contact can then propel the officer to investigate further, and that's what happened here. And listed in my brief, and I went through them, I'm not going to go through them again. There was quite a few factors that Sergeant Nemistil observed that warranted him asking Mr. Korn to get out of the vehicle, and then pinpointing that odor coming from him. There's a bunch of cases, that talk about this. I cited State versus Beal from this court, which relies heavily on State versus Bobo, and they list 4 factors that when something may start out as community caretaking or consensual, there are factors that can be considered, which then permit the officer to propel it to the next level of investigation, beginning with location, officer experience, the suspect's conduct, and or appearance, and any other circumstances. So all those facts that I listed and went through, the state would argue propels this to the next level. And the last thing I'm going to say is, I would argue if we took Mr. Sheldon's brief in his first 2 paragraphs in the statement of facts, which I pointed out in my reply brief, it left out a couple of the important facts. But even if you just take his version of the facts, the first 2 paragraphs, his version of the facts, I would argue, warrant Sergeant Nemistil continuing to follow up and asking Mr. Korn to get out of the car. Again, it's not about probable cause. It's not about proof beyond a reasonable doubt. It's about, was Sergeant Nemistil reasonable? And I'll leave it with the state argues that Sergeant Nemistil was reasonable in following up on this. Thank you for your time.
Thank you, counsel. Attorney Sheldon.
Thank you, Your Honor. May it please the court, David Sheldon on behalf of Maurice Korn. I know this court's been down this road many times, hundreds of times on these cases. That you get these routinely, I understand that. And I know you also receive from the surrounding municipal courts in the 4 counties decisions which point out the Evans factors. And I don't know the court's position on the Evans factors, but I know that these cases have come up several times where there's citations to the Evans factors, obviously from a different district court. And this court has reviewed those cases several times. But I guess the emphasis for me is this trooper, Sergeant Nemistil, he knew almost immediately, and it's on page 15, the transcript. If you look at the transcript, he knew almost immediately that Mr. Korn did not need any assistance. His car was not broken down. He did not need medical assistance. And Mr. Korn explained immediately why he had pulled over. And I think that was it on page 15. I think it was 223 is when he knew he didn't need assistance. And I think by page 16, it's transcript, by 253, he's indicated he doesn't need any type of emergency assistance. He doesn't have any medical condition. His car is not broken down, and he acknowledges that's correct. So It was a very limited conversation. He says at times his words were slurred. He also admitted at the bottom of page 16 of the transcript, he didn't know my client, obviously never been to him before. It seemed that his words were slurred at times. And I don't know if that's his normal speech is what he said. And so he never followed up on that, but he never said, is that your normal speech? Obviously, my client testified at the suppression hearing. It is his normal speech because he'd been boxing for 15 years, but Sergeant Nemmel still didn't care about following up with that question to see if that was a normal speech impediment, which it was. The court, even though Mr. Lanier points out, you
Counsel,
can't take, yes.
Counsel, I'm sorry. I'm just wondering, you're saying that the sergeant should have followed up with the question and said, do you usually slur your words?
I think that would be reasonable because the trooper's just assuming, I'm assuming because he detected some kind of odor of alcohol coming from the car, but he didn't know there was no admission of drinking at that point. I think he's assuming because of that, and he's got bloodshot eyes, that his speech impediment or slurred words must be due to alcohol. Well, I'm not saying he can disregard anything that my client would say if he followed up on questions, but I'm saying in terms of all the factors here, the slurred speech is not a significant factor, as the court pointed out in and of itself. And the court did not disregard slurred speech because it did not cite factor 6 about slurred speech as weighing in favor of my client. So it's not as though the acting judge disregarded slurred speech. I think the acting judge was just trying to point out, this factor, even in and of itself, is not going to weigh heavily in this court's decision, although obviously it's a factor to consider and whether or not there's reasonable articulable suspicion to continue the detention. So I agree with Mr. Lanier. It's not a fact that a court can take judicial notice of. Everyone has different speech. So that's not something that's common and can be easily determined without reference to any other materials. That's not true. Everyone's got different speech patterns. So you can't take judicial notice of someone's speech impediment. But and obviously he didn't know that. The trooper didn't know that at the time because he never followed up with questions as to, why do you have this speech problem? Is it due to alcohol or is there any other explanation? But my point is this detention was continued right from the outset with very little information, I think, that he could rely upon saying this guy's, under the influence of alcohol. He knew immediately that he didn't need help. His car wasn't broken down, but he continued to ask him questions. But getting back to the acting judge's decision, under the totality of circumstances, he was in the best place to evaluate the facts and make a determination as to whether or not the facts fit the appropriate legal standard. I'm not saying high, and that was my case. I'm not saying high is determinative in this case. I was just pointing out high in this case because the court said 2 indicia of impairment were not sufficient to get somebody out of the car and do field sobriety tests. I'd like to point out that the acting judge pointed out 6 factors. In Evans, there's 11. There's actually 7 factors because he missed the intensity of the odor. The trooper never qualified the intensity of odor he smelled coming from the vehicle. Again, he didn't know if it was coming from my client. He didn't know whether it was coming from the passenger. But as I pointed out, the court was in the best position to weigh these facts and determine whether or not there was sufficient articulable suspicion to detain my client. Again, the acting judge pointed out, and I pointed out in my brief, and I differed with Mr. Lanier in this, because Mr. Lanier said, well, in a community caretaking function, a police officer never would see impaired driving and under the circumstances. Well, that's not true. I know this court's had cases where officers pull over vehicles for slow movement and pull them over because they're concerned maybe the driver needs help, et cetera. Well, slow movement or slow, I know there's decisions from this court that says just because someone's going way under the speed limit and you feel they may be, there may be some kind of emergency situation, that's enough. That's not enough to pull them over and conduct a stop. Well, similarly, in this case, you could have someone swerve over 3 lanes, pull off the road and turn on their turn signals before the officer gets to the car or turn on their flashers indicating they need help. Or you could have someone with exhaust pouring out of a lot of exhaust pouring out of the tailpipe and then swerve off the road and turn on their flashers. So there could be situations where an officer could see some type of limited impaired driving although they're responding to a community caretaking function. In this case, obviously, Sergeant Nemestool did not see any impaired driving. He was, and I take issue when Mr. Lanier says you can't be pulled off the side of the road on the interstate. There's no law that says that. He's referring to his experience that if you're on the interstate, you can't pull off and put on your turn signal or your hazards. Well, that's not true. There are emergency situations, and there are situations when people can pull off the road, and even though it's on the interstate. And in this case, my client explained the exact reason why he did it, because he wanted to adjust his GPS, and he was concerned about doing that while driving, which I thought was a prudent thing instead of trying to do it while he's driving. So,
And he had to go to the bathroom, he said.
and he had to go to the bathroom, right? So whether or not, whether you're on vacation and your kid's in the backseat crying, Dad, to pull over, I got to go to the bathroom, and you pull over and let him go to the bathroom, or you wait till the next rest stop. I guess that's something the court will have to reconcile in terms of whether or not
Well,
that's an emergency
I guess what
situation.
I'm still trying to figure out, though, I don't think anybody is alleging this was a stop because he was pulled over. It's a
Right.
matter of the officer, the sergeant approached him, and there's no problem, I don't think, with even approaching him. I think the problem lies, from what I'm hearing from you, is, and what the trial court said, he didn't have reasonable articulate suspicion to continue with his investigation and ask him to step from the car.
That's correct, Your Honor.
Okay, so we're not
That's
really,
correct.
so I'm not sure I understand why even erratic driving comes into play, because this wasn't a stop situation.
No, that's correct, Your Honor. But the issue also becomes, I think, there is the issue of getting him out to do field sobriety tests, but there's also the issue of, do you continue right from the get-go detaining him when it's not an emergency situation, he doesn't need help, and his car's not broken down. He continued to ask him where he's coming from, where he's going, is this a rental car, et cetera. Nothing related to the issue, does this driver or his passenger need medical assistance, or is the car broken down? So he gets into this colloquy of asking additional questions that he knows at that point he doesn't need medical assistance and the car's not broken down. And then we get to the point after he asks further questions, well, based on all the things he observes during questioning and after he's done questioning, is that enough to get him out? And I think the trial court was in the best position to determine those facts and apply the facts from Evans, as well as the other cases out of this court's jurisdiction, including State versus Ian High. So I believe that the judge correctly decided. I know we're this court's probably splitting hairs here in terms of what is sufficient to detain somebody and get them out of the car to perform field sobriety tests. And
Well,
this judge...
Counsel, to Judge Carr's last question, it's not incredibly obvious when you read the journal entry whether we're talking about suppressing everything that was observed after you got him out of the car or anything else, because it may be very clear, and I know you both argued the suppression motion, it may be very clear once we get a chance to review it, but it's not wonderfully clear in the judgment entry. It just says motion to suppress is granted. We don't know what we're suppressing or at what point when we just read that. So that's, I think, part and parcel of what Judge Carr's talking about some confusion regarding whether there was erratic driving or, where are we at, the odor of alcohol type of thing. So just so that we're all on the same page here, that as I said, is confusing to, at least to me, because the court never says he shouldn't have, everything he observed after he got him out of the car is suppressed.
Yeah, I understand that, Your Honor, and it's my position that everything, once he got him out of the car, should be suppressed. Everything flowing from that point onward is my belief as to his ruling. I mean, obviously, once you get him out of the car, he's saying he shouldn't have got him out of the car to do any field sobriety tests. And I know and Mr. Lanier would agree with me, I know there were field sobriety tests performed in this case, and obviously a subsequent arrest and charge for OVI. So my argument would be everything stemming from the point he's asked to step out of the car and perform any type of field sobriety tests. So based on all that, Your Honors, again, I would ask the court to affirm the decision of the acting judge in this case in terms of his granting the motion to suppress. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which we mail to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Again, counsel, thank you both for a very good argument this morning, and thank you for agreeing to appear via video conference. The court is adjourned